These are in listen-only mode.
Good morning and welcome to the America Invents Act webinar series. I'm Lauren Pafumi with the FLC Management Support Office, and I'll be facilitating this webinar. Today is our second session in which we will cover patent-related final rules. This webinar will be about 1 hour long and will cover Inventor's Oath and Declaration, pre-issuance submissions, supplemental examination, and citation of patent owner claim scope statements. There will be 3 Q&A sessions, one after each of the first 2 topics, and a final session at the end of the webinar. Please enter your questions in the questions chat box in your webinar menu, which should be on the right-hand side of your screen. This webinar will be recorded, and the recording will be online within 24 to 48 hours. You will receive an email with information about how to access the recording. For technical questions or issues, please type your issue into the same questions or chat box in the webinar menu for immediate assistance. Our speaker today will be Janet Gongola. Ms. Gongola is the Patent Reform Coordinator at the U.S. Patent and Trademark Office. In this capacity, she manages all aspects of the USPTO's implementation of the America Invents Act. In addition to being responsible for the rules packages, she has been working very hard to educate the public on the new policies through roadshows, webinars, written pieces, and many other events and venues. She also teaches at the George Washington University Law School. Previously, she has provided legal advice to agency officials, defended USPTO board decisions in federal and district courts, and served as a law clerk, patent attorney, patent agent, and research chemist. Many thanks to Janet for joining us today. Now I'd like to turn the floor over to her.
Good morning. I am very pleased to participate in this webinar today to cover my favorite topic, the America Invents Act, with you. Thank you very much to the Federal Laboratory Consortium for organizing it and to Lauren Pafumi for her kind introduction of me. I met Lauren at the Federal Laboratory Consortium annual meeting in Pittsburgh this past May, and she has been wonderful support in devising ways to educate you about the new patent law, including this webinar series and an email column that I write for the FLC newsletter. I'm especially grateful to her, and I admire her dedication and energy. When President Obama signed the America Invents Act into law, he aimed to modernize America's patent laws, reduce the backlog of unexamined patent applications, spur innovation, create good jobs, and grow our economy. With 7 provisions going into effect on September 16th of this year, as seen in the first column of the table featured on this slide, we are steadily moving forward to accomplishing President Obama's objectives. As Lauren mentioned, I am going to focus on 4 of those provisions today: the Inventor's Oath or Declaration, pre-issuance submission, supplemental examination, and the citation of patent owner claim scope statements. I'll take questions after each of these topics. In the next webinar in this series, Judge Sally Medley of the Patent Trial and Appeal Board will address the administrative trials of inter partes review, post-grant review, and covered business method review. I also want to note that the agency is currently making rules for the first inventor to file provision, which is effective on March 16th of 2013, and the agency is in the process of setting or adjusting all of our patent service fees, which we plan to have in place in the spring of 2013. We are taking your comments about our proposed rules for both of these provisions until November 5th at the email addresses shown in the second column of the table featured on this slide. The slide indicates that the comment period closes for the first inventor to file provision on October 5th, but we have since extended the comment period until November 5th in response to requests from the public for additional time. You heard many details about our first inventor to file proposals from Dr. Kathleen Vonda at the first webinar in this series on October 2nd. I hope you will consider providing your feedback on the different aspects that Dr. Fonda discussed with you, both those you favored and those you disfavored. The agency believes that the best work product results from the collective thinking of all of those in the patent community. We have used that philosophy in making the rules I will cover today, and we continue to embrace it for our first inventor to file rules and our patent service fees. Now the slide on the screen reflects the history of our rulemaking for the 4 provisions I will cover today. In January and February of this past year, we released our proposed rules and solicited your input. As shown on the pie graph on the left-hand side of the screen, we received 123 comments from the various organizations shown in the pie chart about our proposals. We carefully considered your feedback and made numerous modifications in response. As you'll see in the slides going forward, changes based on your public feedback from the proposed to the final rules are shown in italics. I won't single them out, but I want you to understand the basis for the italics font throughout the presentation. Now let's begin with the inventor's oath or declaration provision. This provision and the implementing rules that the PTO promulgated aim to simplify and streamline the process and the information required for filing an inventor's oath or declaration. In particular, the AIA amends Sections 115 and 118 of Title 35 to address 3 different concepts. First, who can be a patent applicant? Second, the contents required for an oath or declaration. And third, the timing to file an oath or declaration. The provision applies to all applications filed on or after September 16th of this year. Now, under the amended version of Section 118, an assignee, obligated assignee, or a person who shows a sufficient proprietary interest in the claimed invention may now file a patent application. In view of the amendment to Section 118, the term applicant is no longer synonymous with the inventor. This change does not mean, however, that inventors will be excluded from the patent application process. Inventors, when available, are still required to submit an oath or a declaration. And when inventors are not available, a non-inventor must file a substitute statement identifying the inventors. So let's now turn to the naming of an inventor in a patent application. Under amended Section 115, an inventor can be named in a patent application in one of 3 different ways depending on the circumstances. First, through a traditional inventor's oath or declaration. Second, through a substitute statement filed by a non-inventor when the inventor is not available. And we'll talk about substitute statements momentarily in more detail. And then third, through an assignment document containing the required statements from an inventor. Now we'll focus on the traditional style inventor's oath or declaration. Section 115, as amended by the AIA, simplifies the information that an inventor must supply in an oath or declaration to 2 statements: that the inventor authorized the application to be filed, and that the inventor believes himself or herself to be an original inventor of the claimed subject matter. Section 115, as amended by the AIA, eliminates the requirements for an inventor to state his or her country of citizenship, that he or she believes him or herself to be the first inventor, and that he or she acknowledges the duty of disclosure and has reviewed and understand the contents of the application. So the elimination of these 3 required statements makes it easier for an inventor to execute an oath or declaration. Furthermore, foreign priority claims may no longer be included in an inventor's oath or declaration. They must be presented in an application data sheet only. As an aside, domestic benefit claims also may no longer be included in the specification. They too must appear in the application data sheet. The USPTO has made this change to centralize the location of foreign priority or domestic benefit information to a single location. The USPTO also has created downloadable forms for an inventor's oath or declaration that are available on the PTO website at the address shown in the third bullet on this slide. Now we'll turn to substitute statements. A non-inventor may file a substitute statement in only 4 narrow circumstances listed on the slide for you, which are similar to those today. They are where an inventor is deceased, legally incapacitated, cannot be found or reached after diligent effort, or is recalcitrant and refuses to sign an oath or declaration. Additionally, the non-inventor who may submit a substitute statement is restricted to being an assignee, obligated assignee, or a person with a sufficient proprietary interest in the claimed invention. The narrow circumstances for a substitute statement prevent an assignee, obligated assignee, or a person with sufficient proprietary interest from sidestepping an inventor. Further, a substitute statement must contain 4 specific items of information. First, the statement must identify the entity executing the statement, and second, identify the permitted basis under which the non-inventor is filing the substitute statement, i.e., one of the 4 conditions listed on the slide. Third, the substitute statement must identify the inventor to whom the statement applies. And fourth, the substitute statement must contain those statements required for an inventor, i.e., that the named inventor is an original inventor of the claimed subject matter. The non-inventor no longer must supply proof that the inventor refused to execute the oath or declaration or cannot be found after diligent effort. Both of these are a change from the requirements in the law today. The Patent Office again has created downloadable forms for substitute statements that are available on our website at the address shown in the second bullet on this slide. Now lastly, an assignment may serve as an oath or declaration if the executed assignment includes the information and statements required for an oath or declaration, meaning that the inventor states that he is an original inventor of the claimed subject matter and authorized the application to be filed, and a copy of the assignment is recorded in the office's assignment database. There are 2 options to record what I'm going to call a dual-purpose assignment declaration, electronically and in paper. For electronic filing, the best practice is to submit the dual-purpose assignment declaration for recordation in the electronic patent application system. We call it EPAS, on the same day that the application is electronically filed via the EFS web system. And on the cover sheet of that electronic submission, an applicant should place a conspicuous indication, such as a checkbox, to indicate the dual purpose for the document. If this conspicuous indication is present, the office will make the joint assignment declaration available in the assignment database, and they likewise will forward the document into the application file. Now for a paper filing, the process is somewhat similar. The joint assignment declaration and application should be filed together, And the applicant should use a conspicuous indication, such as a checkbox on the cover sheet, to show that the document is serving a dual purpose. In that case, then, the office will transfer a copy of the assignment document from the application file into the assignment database for recordation. There would be no surcharge when in either the electronic filing scenario or the paper filing scenario the processes I described are followed. Now let's go to the timing for an inventor's oath or declaration. And at this point, I'm using that term, inventor's oath or declaration, as a term of art to cover a traditional inventor's oath or declaration along with a substitute statement or a dual-purpose assignment declaration. An applicant may file, term of art, inventor's oath or declaration with the application, as is done today, or the applicant now may delay filing until the office issues a notice of allowability. But there is a condition that applies if the applicant wants to wait until receipt of a notice of allowability. The applicant must file an application data sheet with the application, identifying each inventor by his or her legal name with a mailing address and a residency. In extending the time period to file an inventor's oath or declaration, the office recognizes that inventors often cannot be identified until the claims have been allowed due to the scope of claim amendments that might be made during the prosecution of an application. Additionally, the timing extension provides applicants with a longer window to locate inventors, especially today when business is global and it is necessary perhaps to secure inventors' oaths or declaration from inventors located around the globe. Nevertheless, we're requiring the identification of all of the inventors on this application data sheet so that we will know who the inventors are and will apply the correct prior art to the claimed invention. An application data sheet is going to serve this notification of inventor function for the office. Also, I should mention that a surcharge applies if an oath or declaration is not present on the filing of the application. In contrast to an original application, I should also mention that an oath or declaration must be provided before the examination of a reissue application. Now at this point, I'm going to stop and take your questions on the inventor's oath or declaration provision. And I see through the chat function that we've received a series of questions, so I'll walk through each of them as they've come in. I'll read the question to you and then provide you with an answer to the question. Okay, so the first question that we have received is for a PCT application entering the national stage after September 16th of 2012, which version of a declaration is required, the pre-AIA version or an AIA version? Earlier I indicated that the filing date of an application controls which version, pre-AIA or AIA, of an inventor's oath or declaration applies. So for a PCT application entering the national stage after September 16th, I presume that the international application was filed before September 16th of this year. That means that the pre-AIA version of a declaration is required. The filing date for a PCT application is treated as the international filing date, not the date of national stage entry. Our next question: if an inventor cannot be found or refuses to execute an oath or declaration, who owns the patent if one is eventually issued? The patent is going to issue in the names of the inventors, but I assume that if an applicant or the inventors cannot be found or refuses to sign, then the applicant in that scenario is going to be a non-inventor. But the application itself will issue in the names of the inventors. Next question. If there are multiple inventors, can an applicant piecemeal the submission of the inventor's declarations, or do all declarations have to be submitted at the same time? An applicant can piecemeal the submission of inventor's oaths or declarations if the applicant submits the application data sheet with the application. And on that application data sheet, the applicant identifies all of the inventors coupled with their mailing address and residency. Then the office will know who the inventors are likely to be, can apply the right prior art, and the applicant will have more time to collect the inventor's declarations, which now can be filed declaration per inventor. A single declaration does not have to cover all of the inventors. So an applicant can submit the inventor's declarations one by one across the course of prosecution for an application, but the final inventor's oath or declaration must be submitted no later than the close of the period after the notice of allowability, which is a 2-month window after a notice of allowability is issued. Okay, next question. If there are multiple inventors, do they all have to sign the same declaration? Or can each inventor now submit his or her own declaration? Yes, inventors now can submit an individual declaration. If there are multiple inventors, they all do not have to sign the same declaration. Next question. If you file a divisional application after September 16, 2012 that claims priority to a non-provisional filed before September 16, 2012, do you use the old or the new oaths or declarations? The concern is that the new declarations do not contain the first language that is required for the application to be subject to the first to invent laws. If you file a divisional after September 16, 2012, you must file an AIA-style declaration. The filing date of the divisional is after the effective date of the oath declaration provision. Therefore, the AIA requirements apply to that divisional application. Now, the concern goes to the fact that there is a period of time from September 16th of this year until March 16th of 2013 when we are still under the first to invent system. But the AIA has removed the requirement for an inventor to state that they are the first inventor of the claim subject matter. That is the requirement of the law. We recognize that there is a period of time that inventors will not be stating they are the first inventor of the claim subject matter for this 5-month duration, but those are the technical requirements of the AIA. So it's acceptable in that declaration for a divisional filed after September 16th, 2012 to only make the two statements that the inventor is an original inventor and they authorized the application to be filed. Now, if an inventor wants to also state they are an first inventor of the claim subject matter, they may continue to do so. That would be considered an extra statement. The Patent Office would not bounce the application or the inventor's oath or declaration based upon the presence of that extra statement, but the extra statement is not required. Okay, I think that's going to wrap us up on all of the questions we've received so far on the oath or declaration provision. So I'm going to move on to our next topic of pre-issuance submissions. But if you have further questions on the oath or declaration provision, please feel free to submit them. We have 2 more question and answer sessions, and I'd be glad to cover them during one of those next 2 sessions. So moving back to our slides, the pre-issuance submission provision in the AIA and the implementing PTO rules aim to improve the quality of patent examination by placing the most relevant art into an application file as early in the examination process as possible. By having the most relevant art available early, an examiner will be able to make a quick and efficient patentability determination for the claimed invention. The AIA amends Section 122 of Title 35 by adding a new paragraph E to provide for these pre-issuance submissions. A pre-issuance submission may be filed by a third party in any pending or abandoned non-provisional utility, design, or plant patent application filed before, on, or after September 16th of 2012. The key is that the application is pending or abandoned. Now, if a pre-issuance submission is filed in an abandoned application, an examiner is not going to consider it unless the application returns to a pending status. For instance, if the application is revived or the notice of abandonment is withdrawn. This is necessary to conserve examination resources. A pre-issuance submission also may be filed in a continuation in part, or a divisional application. A pre-issuance submission may not be filed, though, in an issued patent, a reissue application, or during a re-examination proceeding. The pre-issuance submission provision permits a third party to submit a printed publication into the record of another's patent application if 4 conditions are met. First, the submission must be made within the statutory time period, which we'll talk about. Second, the third party must provide a written explanation of the relevance of the reference. Third, the third party must pay a fee. And lastly, the third party must file statements attesting to compliance with the statute and the PTO's rules. The term printed publication is discussed in the Manual of Patent Examination Procedure in Section 2128. The term is meant to include, for example, U.S. patents, U.S. patent application publication, foreign patents, foreign patent application publications, and journal articles. Printed publications do not include documents such as an internal corporate memo or a document filed in a court proceeding and subject to a secrecy order. If the publication date for a document is not known, then the third party must supply evidence of publication. At a minimum, the third party must proffer the date of retrieval or time frame when the document was available as a publication in the form of an affidavit or a declaration. Also, a pre-issuance submission may be filed in paper form or via the EFS web system, but it cannot be filed by facsimile. I encourage you to use the EFS web system for a couple different reasons. First, it walks you through all of the required items of information so you won't omit anything. Additionally, it calculates the timing to ensure that the submission is being filed within the statutory window. Now, a third party is not required to serve a pre-issuance submission on an applicant. And the reason for this is we want to avoid a challenge as to whether the service was proper. If an applicant signs up for e-office action, the Patent Office will alert the applicant that a submission has been made into the application file. And I'll talk about this a little bit more momentarily. Finally, a pre-issuance submission cannot be filed anonymously. The submitter must sign the submission. But if a third party wants to preserve the confidentiality of their identity, then they can make a submission through a registered practitioner who can sign the submission on their behalf. And that way, they will preserve the confidentiality of their identity. The AIA sets a strict timing window within which a third party may file a pre-issuance submission. The submission must be made before the earlier of the date of a notice of allowance or the later of 6 months after the application is published or the date of a first rejection. The office treats the filing date of a pre-issuance submission as the date the office receives the submission, and the office must receive the submission before the critical date. This strict timing window is intended to avoid applicant harassment. And a third party can determine whether their submission is going to be within the strict statutory window by consulting public pair. There are 6 items of information that must be included by a third party in a pre-issuance submission. First, the third party must provide a listing of the printed publications, and a third party can do so either by a special form for a paper submission that the office created and is available on our website at the address shown in the dash under the first bullet, or electronically on EFS Web. Third parties are not required to use our form. You can create your own form if you so choose. Second, the third party must provide a concise description of the relevance of each printed publication included in the submission. A concise description of relevance is intended to be a statement of facts explaining how a particular document potentially bears on the patentability of the claimed invention. The third party should point out the pages, the lines, the figures, the footnotes, where the relevant information is located in the printed publication with a description of the potential issues raised by the cited text. A compliant, concise description has to be more than something like this document might be relevant to the claimed invention, but it should be something less than a full office action rejection that the examiner can simply copy and paste into an office action. Furthermore, a concise description of relevance should not attack an examiner's rejection or an applicant's response to that rejection. We have received 95 pre-issuance submissions as of the close of business last Friday. The majority of those submissions have been compliant, but the few that failed because of non-compliant concise descriptions of relevancy. So this is probably the most sensitive area for a pre-issuance submission. I am preparing a more elaborate discussion of what the concise description of relevance requirement contains, and I will be posting that on our AIA microsite today, along with some examples that you can look at to see the difference between a compliant and a non-compliant concise description of relevance. Now third, a pre-issuance submission must include copies of the printed publication contained in the submission except for U.S. patents and U.S. patent application publications, which the PTO can easily access. Fourth, the submission must include translations for any non-English language document, but the translation does not need to be certified. And then fifth, 3 different statements are potentially required: the statement of compliance with the statute and rules, a statement that the submitter is not subject to a duty of disclosure, meaning that the submitter is not the applicant, and then lastly, whether the fee exception applies. And we'll talk about that more momentarily. And then the 6th item is an actual fee. A third party must pay a fee of $180 for every 10 documents or fraction thereof. But the PTO has created a, quote, 3 for free exception. If a third party submits 3 or fewer documents, the submission is free. The 3 for free exception is designed to encourage a focused submission of the best documents. The exception is available for more than one third party in a given application. And then further, a third party who takes advantage of a submission, of the fee exception, may make a subsequent pre-issuance submission where the need for such a subsequent submission was not known at the time of the earlier submission. And then for the second or subsequent submission, the party will be subject to the $180 fee or fraction thereof for every increment of 10 documents submitted. Okay, this slide is intended to show you how the office will process pre-issuance submissions. So we'll start with the blue triangular box. Upon receipt of a third-party pre-issuance submission, a TC representative will review the submission to determine if it's compliant with the statute and the rules before making the submission of record. Moving across the horizontal arrows, a compliant submission will be made of record, and the examiner must consider it as part of the examination of the subject patent application. The patent owner will be notified if the submission is made of record if the patent owner participates in the e-office action program. So I encourage patent applicants to participate in e-office action so as to receive notifications if any pre-issuance submission is included in their application file. Now, there are many more reasons for why you'd want to participate in e-office action, but for purposes of the pre-issuance submission provision, this is the main one. Now, going down the vertical non-compliant arrow, a non-compliant submission will not be made of record, but instead it's going to be discarded. The third party will be notified by email of any defects in the submission if the third party provides an email address with the submission. Now, a third party cannot correct a defective submission, but instead they're going to have to make the submission over again, making sure that the item of defect is corrected. The third party is not going to be able to respond to an examiner's treatment of a submission, and a patent applicant is not required to respond to the submission. If an issue arises as a result of the pre-issuance submission and the examiner would like more information from the applicant, then the examiner is going to issue a request for information under Rule 105. Such requests are rare and they're going to be limited in scope, but the office does have a mechanism to engage the applicant regarding a pre-issuance submission if the examiner determines it's necessary to do so. Finally, printed publications contained in a pre-issuance submission will be printed on the face of a patent in a distinct section from submissions that an applicant makes through the IDS process. But the face of the patent will show all documents that the examiner has considered when evaluating the patentability of the claimed invention. Okay, now at this point, I'm concluding our discussion of pre-issuance submissions, and I'll stop and take additional questions that you have about this topic or inventor's oath or declaration provision. Okay, I can see that we have a couple of questions coming in on pre-issuance submissions here, so let me read the first one. Let's see, the first one is, what is the purpose of third-party pre-issuance submissions? The design of the provision is to allow a third party to put the best and most relevant art into an application during the examination process for the application so that the examiner can make a swift decision on patentability. We don't want the examiner to never find the most relevant art through a search or engage in protracted prosecution with an applicant all the way through up to 3 years, only to then have the best item of information come out to the examiner's attention. Should that happen, and it turns out that the particular item of information establishes that the claimed invention is not patentable, then the applicant, along with the examiner, will have spent considerable resources, human resources, financial resources, trying to prosecute an application that's no longer, that is never going to be in condition for allowance. So we want to get the best information early to achieve compact prosecution. Okay, next question. Is there any limit on the number of printed publications that can be filed by a third party in a pre-issuance submission? No, a third party can file however many documents the third party would like in a pre-issuance submission. If the third party will be required to pay a fee of $180 for every increment of 10. So let's say that the third party would like to submit 17 documents. The third party may do so in a single submission at a fee of $360. $180 for the first 10 documents and an additional $180 for the next 10 or the next 7 documents. Oh, I have a comment here. Please inform the speaker that on slide 16, patent owner is not correct because the submission can only occur prior to the issuance of a patent application. Thank you for this comment. That is correct. On the slide that you can see in the purple circle going across the horizontal arrow, instead of patent owner, the text should say patent applicant notified if e-office action participant. Okay, looking for more questions on this topic. A question here is, can a pre-issuance submission be filed in a continuation application or in a request for continued examination? Yes, a pre-issuance submission may be filed in a continuation or in a request for continued examination. Can you give, another question, can you give an example of what would qualify as a concise description of relevance? A concise description of relevance would be something along the lines of, I refer to patent application ABC 123 at column 2, lines 54 to 56. The passage there points out that limitation A of the claimed invention is recited in the text. So you're mapping specifically into the submitted printed publication and tracking it to the limitations of the claims so the examiner can see how the printed publication bears upon the patentability. A concise description of relevance can take the form of a narrative, as I just described to you. It could also take the form of a claim chart that shows in one column the specific parts of the printed publication you are citing, matching up with in another column the specific limitations that are taught or rendered obvious by that cited text. I don't believe we have any more questions at this time.
Hi, Janet. Actually, I think we've actually got a couple coming in that I'm not sure. Maybe they're up above your chat. But if you don't mind, I'll read you a few because it seems like there's some pretty good ones that have just come in the last few minutes. So okay, so I have in your answer regarding oaths and declarations for divisional applications filed after September 16th. But with a parent having a filing date prior to September 16th, you indicated that a declaration in compliance with post-AIA rules was required. This would seem to be inconsistent with the generally acceptable practice of filing copies of declarations from the parent with divisional application. Does the PTO really intend that new post-AIA declarations must be prepared and signed by inventors of divisional applications which claim the benefit of a parent filed before 9/16/2012?
Yes. In a divisional application filed after September 16th, The AIA rules apply, so a new inventor's oath declaration would likely have to be executed. It's the filing date of the application itself and not the priority benefit claim that governs what version of a declaration, pre-AIA or AIA controls. So my answer was correct. We do intend for a new declaration to have to either be executed, or the declaration from the parent application will have to be supplemented with the required statements required under the AIA, original ownership and authorization to be filed, and executed again by the inventor.
Okay, our next question is, will the applicant have the opportunity to dispute the statements of relevance made by the third-party submitter?
No, an applicant will not have the opportunity to dispute the relevance. An applicant is not required to comment on the statements of relevance. An applicant can choose to make a submission in response to seeing that a pre-issuance submission has been made into an application, but it is not required for them to respond to it. I suggest that the best practice would be to allow the examiner to look through the pre-issuance submission. If the examiner determines that any of the submitted printed publications bear upon the patentability of the claimed invention, then the examiner will make a rejection, at which time the applicant will have a chance to respond. If the examiner does not rely upon any of the printed publications, then the applicant need not do anything. The examiner has considered them, determined that they don't bear upon patentability, and will not be making a rejection. So an applicant can save themselves resources and work by just waiting to see what the examiner does, and then they'll have an opportunity to respond if the examiner actually applies any of the cited printed publications.
Okay, next question is, if a third party resubmits a document discarded by USPTO previously, does it count as a new document for the fees?
Yes, if the third party submits a document that's already been cited, perhaps by the applicant in an IDS, that document will be included in the fee count. The third party might want, in that instance, if they're submitting a document that the applicant has already put on file, the applicant will not have discussed the relevance. The third party may want to elaborate on the relevance of the document to point the examiner to the specific passages that bear upon the claimed invention.
Okay, we just have two more questions here in the queue. So the first one is, if non-compliant, will the reason for non-compliance be communicated to the third party?
Yes. When the office makes a determination that a third-party submission is not compliant, we will notify the third party. We will explain why the submission was not compliant, and then the third party will have to redo the submission. They can't correct the defect in an existing submission. They will have to make the submission with the defect corrected over again and pay again for any fee that's owed.
Okay, and the final question here is the fee for making a third-party submission subject to the small entity discount?
No. The fee for a third party to make a pre-issuance submission, I do not believe, is subject to the small entity 50% discount. It's the full price.
Okay, so now we seem to be caught up on questions, so I think if you want to
Okay, then we will
next.
move on to supplemental examination. The supplemental examination provision and the PTO rules are designed to provide a straightforward way for a patent owner to cleanse any inequitable conduct that might have been committed before the Patent Office during the prosecution of the application that ultimately issued as a patent. The supplemental examination provision was included in the AIA in response to a flood of inequitable conduct cases that plagued the court system over the past several years. The AIA introduces a new Section 257 into Title 35 to set forth the scheme for supplemental examination. Supplemental exam becomes available on September 16th for any enforceable patent. And a patent is generally enforceable for 6 years after its expiration date. A patent owner may request a supplemental examination of a patent for the office to consider, reconsider, or correct an item of information believed to be relevant to the patentability of the claimed invention. So let's break this down a little bit. Only the owner of the entire right, title, and interest in a patent may seek a supplemental examination. A partial owner or exclusive licensee cannot, nor can a third party ever participate in a supplemental examination. Also, the request for supplemental examination may address any condition for patentability, 101 to 112 along with double patenting. And an item of information is not limited to a patent or a printed publication. It simply must be in writing. And it could include, for example, like a sales receipt or a video where a transcript of the video is provided. Lastly, a single request for supplemental examination is limited to 12 items of information. But a patent owner may file more than one request for supplemental examination at the same time to place as many items of information as desired before the Patent Office. And I'm going to refer you to some questions and answers on the microsite for examples of how to count the 12-item limit. Now, a supplemental examination request may be filed electronically or in paper, but not by facsimile. The request should clearly be identified as one for supplemental examination to avoid the filing merely being placed into the application file without any further action. Because the request is going into an issued patent, normally we don't take action on pieces of paper submitted into an issued patent. That's why it is important to clearly identify the submission as a request for supplemental examination. The PTO has created a special transmittal cover sheet that clearly marks the submission as a supplemental examination request. The transmittal form is listed or is available at the PTO website on the address at the third bullet in the slide. There are 5 required items that must be included by a patent owner in a request for supplemental examination. First, the patent owner must identify the patent and the claims for which supplemental examination is requested. Second, the patent owner must list the items of information to be applied against each and every one of those claims. Third, the patent owner must explain the relevance of each item of information as to each claim to which it applies. Fourth, the patent owner must summarize documents that are over 50 pages in length, and this includes patent as well as non-patent documents. But notably here, the request for supplemental examination itself is not page restricted. And then lastly, the patent owner must pay some fees. In sum, these requests or these items are akin to those required for an ex parte reexamination request. Now, the fees for supplemental examination. A patent owner must pay a filing fee in the amount of $5,140. And then, if reexamination is ordered as a result of the supplemental examination, the patent owner will also pay a fee in the amount of $16,120. In total, then, the cost for a supplemental examination due with the request is $21,260. Now, if the office does not order the reexamination, the office will refund the reexamination fee of $16,120. The fees set for supplemental examination were done under Section 41D of Title 35, which requires fees to be set at cost recovery. We projected the cost of supplemental examination based upon our costs for reexamination. Currently, when I mentioned on the first slide our fee setting process, we are now proposing to adjust and downgrade the cost for supplemental examination under our fee setting authority of Section 10 in the AIA. We likewise plan to provide for a staging of the payment of the two fees for supplemental examination, meaning that a patent owner would only have to pay the filing fee up front, and then if the supplemental re-exam, is ordered, then the patent owner would pay the follow-on re-examination fee. Those fees, though, currently, until we exercise fee setting and release our new fees in the spring of 2013, and that today a patent owner must pay the full $21,260 for the supplemental exam with the request. Now this slide shows for you how a supplemental examination will occur before the office. Upon receipt of a patent owner's request for supplemental examination, featured in the purple circle, the agency has a 3-month period to decide whether any item of information raises a substantial new question of patentability. So if not, going down the vertical arrow, then the supplemental examination will conclude and the PTO will refund the fee for ex parte examination as I mentioned. But moving across the horizontal arrow, if any item of information raises a substantial question of patentability, then the PTO will order an ex parte re-examination. But note that even going across the horizontal arrow, supplemental examination concludes. If re-examination is ordered, the ordinary rules will apply except that the patent owner may not file a patent owner statement. We don't need one. The patent owner filed the request for supplemental examination, so the office already understands the patent owner's position. And then second, the re-examination will not be limited to novelty or obviousness issues premised on patents or printed publications. The ex parte re-examination will proceed on whatever basis the request was granted. It could be a 101 or it could be a 112 issue. But when the office issues the certificate of supplemental examination, it will be in electronic form and it will remain in the patent application file even through the ex parte re-examination process and even at the issuance of the ex parte re-examination certificate. Okay, now I'm going to move into the citation of patent owner claim scope statements. This provision and the PTO rules aim to ensure that the Patent Office and the courts have the same information about how a patent owner views the scope of his or her patent claims. That way, both tribunals will consistently treat the patent claims. And this provision applies to any patent that exists on September 16th of this year. The AIA actually expands the scope of information that may be included in a patent file to cover patent owner claim scope statements. Title 35 already permits the inclusion of prior art in a patent file, and either a patent owner or a third party may make the patent owner claim scope statement submission. So what exactly are we talking about here when we use the term patent owner claim scope statement? This is a written statement by the patent owner, filed by the patent owner in either a federal court or an office proceeding, where the patent owner has taken a position on the scope of any claim in a patent. The AIA is going to govern how the office can use a patent owner claim scope statement, and I'll talk about this more next. Lastly, the AIA permits the submission to be made anonymously, thus eliminating the need for the submitter to identify himself or herself to the office. There are 4 requirements for a patent owner or a third party to submit either prior art or a patent owner claim scope statement into a patent file. First, the submitter must identify the prior art or the claim scope statement itself. Second, the submitter must provide an explanation of the pertinence and manner of applying the statement. This means that the submitter, at a minimum, must explain why the prior art or the statement bears upon the patentability of any claim in the patent. Third, if the patent owner makes the submission, then he or she has the opportunity to explain how the claimed invention remains patentable over the prior art or in view of the claim scope statement. And then lastly, the patent owner must provide proof of service. A patent owner doesn't, and this applies only if we're dealing with a third party making the submission. The reason is because a patent owner typically does not check a patent file to see if any documents have been entered into the file. Therefore, we are requiring the third party to serve the patent owner so that he is aware that the submission has been entered into the patent file. Now, the requirements on this slide apply only to a patent owner claim scope submission. And there are 4 more things that a submitter has to do beyond those that we just talked about. First, the submitter must identify the forum and the proceeding in which the statement was filed. They have to identify the specific papers or portions of the papers that can contain the claim scope statement. And then they have to identify how each statement qualifies as a patent owner claim scope statement, how they meet the definition I mentioned a couple slides ago. And then they have to point out any other documents filed in the proceeding that speak to the claim scope statement to give a fuller picture of the context for the claim scope statement. Now, per the AIA, the office will not consider a patent owner claim scope statement when deciding whether to institute an ex parte reexamination or a post-grant or inter partes review. But once a reexamination or one of the reviews is instituted, the Patent Office may use a patent owner claim scope statement to assist in informing the examiner's interpretation of the relevant claims. During a reexamination or one of the reviews, the office is going to apply the broadest reasonable interpretation to the claims. A patent owner claim scope statement may shed light on what that broadest reasonable interpretation is, and hence offer utility to the office. Now, the last couple areas I want to mention are not rules that have gone into effect, but involve a couple different programs that I think you might find of interest. The office has 2 programs to assist independent inventors and small businesses in proceeding before the Patent Office: the Pro Bono program and the Patent Ombudsman program. The Pro Bono program connects under-resourced independent inventors and small businesses with patent counsel to assist in filing and prosecuting patent applications before the office. This program is organized by local bar associations with a patent office representative offering support. We currently have programs running in Minneapolis and Denver, with plans for expansion in California, Texas, and the DC area very soon. The Patent Ombudsman program offers assistance to all patent applicants whose applications have become log-jammed in the office. This would be independent inventors and small businesses, along with any other applicant out there. The applicant can contact the Ombudsman for help in returning an application back on track into normal prosecution. The Ombudsman will resolve the logjam within 10 business days. But note that the Ombudsman is not a substitute in place of the examiner in terms of making a patentability determination. The Ombudsman is a process-only type of resource. Finally, satellite offices. The office opened the first ever satellite office in Detroit, Michigan this past July. The Detroit office currently employs 50 examiners and 10 administrative patent judges. The examiners work on cases in the mechanical and electrical arts. And I also want to note that the Detroit office has a public search facility and public interview rooms available where any member of the public can go access the search capabilities just like are available in Alexandria, or can go and participate in an interview with an examiner located in Alexandria or that may be hoteling from locations across the country. Beyond Detroit, the office has announced that it is going to open 3 more satellite offices in Denver, Dallas-Fort Worth, and Silicon Valley. We have already secured office space in Denver, and we're presently renovating that space with plans to open in the fall of 2013. And our pursuit for office space in Dallas-Fort Worth and Silicon Valley is ongoing. So at this point, I'll take additional questions that you may have about any of the provisions that I have talked about so far: Inventor's Oath or Declaration, pre-issuance submission, supplemental examination, or the citation of patent owner claim scope statements. And I see that questions have come in. The first question, when would a patent owner want to request a supplemental examination? My guesstimation for when a patent owner would like to seek a supplemental examination is in 2 different scenarios. The first is if a patent owner is intending to assert the patent against a possible accused infringer. The Patent Office may want, in that instance, to review the application files to ensure that no art happened to have been overlooked or maybe mischaracterized. And if so, then they might want to seek a supplemental examination. That way, they will immunize themselves from an inequitable conduct attack that could be made if the patent infringement litigation is brought by the accused infringer for the information that's subject to the supplemental examination. The second situation might be if a patent owner is going to acquire a patent portfolio from another company. The patent owner in that instance might want to go through each patent in the portfolio to evaluate, again, whether any art has been omitted or perhaps mischaracterized, and either before purchase or after purchase, engage in a supplemental examination to essentially clean up this patent portfolio so that they're not purchasing for themselves any patent that could potentially have some form of an inequitable conduct cloud hanging over it. Next question. Who at the PTO is conducting a supplemental examination? Supplemental examinations are being conducted by examiners in the Central Reexamination Unit. As of September 16th, applicants could no longer file for an inter-parties reexamination. So that work, which was previously handled by the Central Reexamination Unit, went away. In its place, the Central Reexamination Unit is now handling requests for supplemental examination. And to date, we have only received 2 requests for supplemental examination. Next question. Why can't a patent owner have an interview with the examiner during the supplemental examination? The reason a patent owner cannot have an interview with the examiner is because the office only has a short 3-month window in which to decide whether any of the items of information raised in the supplemental examination request trigger the substantial new question of patentability standard. That's a very short time frame. It's set by statute. We do not have time to conduct interviews with the applicant. The applicant really should have put all of the information that they want to communicate to the examiner in their request for supplemental examination. So on top of the time period being short, there shouldn't be a tremendous need for an interview as part of that supplemental examination. Now, if the office orders an ex parte re-examination to flow from a supplemental examination, then interviews during the ex parte re-examination are permissible. Okay, more questions here. Will an applicant have the opportunity to dispute this? Oh, no, we've covered that one. I'm sorry. Why would a patent owner want to submit a patent owner claim scope statement to the patent office? If a patent owner might want to submit a claim scope statement to the patent office to ensure that the office understands the patent owner's reading or interpretation or intent for the scope of its patent claims. This is particularly true if the patent owner foresees having an bringing an ex parte re-examination for the patent, or they are concerned that a third party may wish down the line to bring one of the administrative trials of inter partes review or post-grant review, while in either an ex parte re-exam scenario or one of the administrative trials, the office wouldn't use the information in determining whether to institute. The office could look to that patent owner claim scope statement if one of the proceedings is then later in time instituted, and the statement could inform the office's broadest reasonable interpretation for the claims. Okay. Another question. The re-examination fees seem very high and would seem to work to preclude such filings. Okay, a little bit to explain, and I assume we're talking about ex parte re-examination in general, which we didn't have a slide for, but those fees have increased from around $2,000 to roughly $16,000, along with the re-examination that flows from a supplemental examination, which is set around $16,000 also. The office has set the fees based upon cost recovery. We are mandated to do so under the current Title 35, Section 41D. Relief is coming because when the office resets our patent service fees under Section 10 of the AIA, we will have more flexibility. We're not restricted to using cost recovery. We can set fees at levels we determine to be reasonable for the service, provided that the aggregate income that the office collects from all service fees matches the cost to operate the office in the aggregate. So relief will be coming down the line. In fact, on supplemental examination, fees are going to drop by about 30%. I don't know the numbers for ex parte re-exam at this point, but those fees are also going to be dropping. Okay, I'm looking to see if we have any additional questions that have come in. And it does not look like we have any additional questions.
There's maybe one more. Did you see about the question, how can an individual or small business get assistance for patent fees, or was that covered in your last?
No, that one I'll take. Okay, so an individual or small business currently should be eligible for a small entity discount of 50% on all fees. The small entity discount is available for individuals or small businesses that employ fewer than 500 employees. Going forward, after the office sets or adjusts all of our patent service fees under the AIA in the spring of 2013, a new type of discount may become available, or will become available, you might be eligible for. It's called a micro-entity discount, which entitles qualifying applicants to a 75% discount on fees. There's two different ways that an applicant can qualify as a micro-entity. One definition is tied to experience with patent filings and income. Specifically, an applicant cannot have filed more than 4 non-provisional patent applications. The applicant must have an income that's less than 3 times the median household income in the year before the fees are paid, which is roughly $150,000. Third, the applicant has to be a small entity. And lastly, the applicant cannot be obligated to assign, license, or convey their invention to what I'll call a large size entity. So if applicant meets those 4 prongs, they can be a micro entity and get a 75% discount. Alternatively, if an applicant is employed by or is under an obligation to assign, license, or convey to an institute of higher education, they also could qualify as a micro entity and get the 75% discount. And one final note there, that 75% discount applies to just about all of our patent service fees, specifically those associated with filing, searching, examining, maintaining, issuing, and appealing. What they don't apply to are the administrative trials. Now going forward, let's see. Okay, I want to leave you, if you have future questions, you can always email me. But we have created AIA helplines. We have a dedicated telephone line, 1-855-HELP-AIA. We also have a dedicated email address, helpaia@uspto.gov. You can submit questions through either helpline. We have a dedicated team at the call center who will answer your AIA questions. Additionally, I would encourage you to check out the AIA microsite. The address is given in the 3rd bullet. There's a huge amount of information there. Frequently asked questions that I mentioned earlier. We have videos. We have slideshows. We have detailed reference guides. It is and always has been one-stop shopping for everything we have to offer AIA-wise. So you may want to check it out. But again, you can always email me or check out one of the helplines for further questions. And with that, I'm going to conclude. I will turn things over now to Lauren for concluding remarks.
Okay, great. Well, thank you, Janet. This concludes our webinar. We really appreciate you sharing your expertise and your time with us today. And we want to thank all of the attendees who participated. You'll be able to find the recordings of this webinar online within 24 to 48 hours. And when the webinar ends, please take a moment to answer the survey questions that will appear. We hope that you'll join us for the 3rd and final webinar in the series, which will cover Administrative Trial Final Rules with Administrative Patent Judge Sally Medley on October 29th.